Welcome to This Explainer. Today, we're setting the stage for a comprehensive step-by-step guide to navigating the Arkansas District Court system. If you've ever felt completely intimidated by the idea of taking legal action, well, you are in the exact right place. We're going to break this whole thing down. Imagine resolving your disputes quickly and efficiently without the need for an expensive attorney. Filing a small claims case in Arkansas could be your solution, and we're here to guide you through every step of the way. Okay, let's dive into this. We're following a clear chronological roadmap today. First, the small claims solution. Then, pre-filing and eligibility. Next, filing your claim, serving the defendant, the court hearing, and finally, post-hearing steps. Let's jump right into Section 1, the small claims solution. So this court is a streamlined division purposely built for regular people. It provides a highly cost-effective and speedy pathway to resolve minor civil disputes. But, and this is a big but, there is a very strict monetary ceiling you have to be aware of, and that is $5,000. If you're trying to recover a security deposit, an unpaid loan, maybe compensation for some property damage, your claim absolutely cannot exceed this amount. If your damages are higher, let's say $6,000, you basically have two choices. You must either waive that excess $1,000 to keep the simplicity of small claims court or file a different, much more formal court division. And this brilliantly illustrates the whole philosophy behind this court system. Arkansas has a strict rule that attorneys are entirely banned from representing parties in small claims court. Collection agencies, yeah, they're explicitly locked out too. The court is strictly for self-represented individuals. Even if a corporation is involved, they are required to send a non-attorney corporate officer or an employee. This intentionally levels the playing field so everyday citizens aren't outgunned by expensive legal teams. It's a real game changer. All right, moving on to Section 2, pre-filing and eligibility. Before you rush off to the courthouse, you really need to ensure your dispute actually qualifies, because in law, timing is everything. You have to know the statute of limitations for your specific issue. In plain English, that's just your legal deadline to file a lawsuit. In Arkansas, if you're suing because someone broke a written signed contract, you generally have a 5-year window from the date that contract was breached. But, and you'll want to remember this, if your claim involves a handshake deal, an oral contract, or property damage like a fender bender, you only have a 3-year deadline. If you try to file after these periods expire, your case will be dismissed, period, regardless of how great your evidence is. So, getting organized early is absolutely essential. Our pre-filing checklist strongly recommends attempting an outside resolution first. Send a formal demand letter via certified mail, giving the other party 30 days to pay up or resolve the issue. While you're waiting on that, start gathering your physical evidence. We're talking contracts, receipts, text messages, invoices, photos, the whole shebang. And here is a pro tip that will absolutely save you a massive headache later. Make exactly 3 copies of all your evidence. One for you, one for the judge, and one for the defendant. Let's keep rolling with Section 3, filing your claim. To officially initiate your lawsuit, you can't just choose the courthouse that's closest to your house. You actually must file in the correct venue. This is the legally mandated district court location for your specific case. Usually, you have to file where the defendant currently lives, where the incident actually occurred, or where the contract was supposed to be performed. For example, if you get into a fender bender in Fayetteville, but the person who hit you lives in Bentonville, you could file in the district court for either of those locations. But pick the wrong venue, and the judge will just dismiss your case. Luckily, the courts actually want to help you get this right. The district court provides plain language instruction forms, like the small claims information sheet you see here. It makes the whole bureaucratic process far less intimidating and clearly outlines exactly what you can sue for and what is expected of you. When you are fully ready, you'll fill out an official complaint or claim form, similar to this one. You'll need to clearly state the names and addresses of the parties, the exact amount of money you're claiming, and a brief factual basis for why you are owed that money. You take this completed form directly to the court clerk and pay a filing fee. That fee generally ranges from $30 to $65, depending on which county you're in. Now, Section 4, serving the defendant. And what's really interesting about this step is how strict the court is about notifying the person you're actually suing. You literally cannot just send them a text message saying, "Hey, see you in court." No way. You must complete formal service of process. Now, Arkansas allows a few different methods for this. You can send the court documents via certified mail with a return receipt requested. Alternatively, you can pay a local sheriff or a private process server to hand deliver the paperwork.
If the defendant is actively dodging you and avoiding service, the court might actually allow a warning order where notice is published in a local newspaper. Whatever method you end up using, Arkansas rules require that the defendant be successfully served at least 10 to 20 days prior to the hearing date. They have to have fair time to prepare.
The very moment that defendant is officially served, a strict timeline begins. They have exactly 30 days to file a formal written answer with the court clerk, outlining their defense. But if the defendant completely ignores the paperwork, if they fail to file that answer within 30 days, the plaintiff has a huge advantage. You might automatically win what's called a default judgment. All right, Section 5, the court hearing. Assuming the defendant answers, you are officially heading to trial. Now, if you're a little nervous, take a deep breath and remember that this environment is fundamentally designed for everyday people to navigate. There are no dramatic TV-style jury trials in Arkansas Small Claims Court. Cases are heard by a judge only. Furthermore, those super strict rules of evidence that apply in higher courts, they are significantly relaxed here. The judge will directly listen to both sides, look at the documents, and apply the law to the facts presented. It's that straightforward. To put your best foot forward, courtroom etiquette is absolutely vital. Arrive early. Always address your remarks to the judge, not the person you are suing. Never interrupt the defendant when it's their turn to speak, and as we noted earlier, have your 3 physical copies of all evidence perfectly organized and ready to go. I highly recommend practicing your delivery before you get there so you can present a really concise, factual case. So the crucial point is, what happens after the judge decides? Let's look at Section 6, post-hearing steps. What happens after the judge bangs the gavel and makes a ruling? Well, a lot of people are surprised to learn that winning a judgment does not mean the court instantly cuts you a check. If the losing party refuses to pay up, the burden is completely on you to actively collect that money. Fortunately, a court judgment gives you powerful legal tools to do exactly that. You can pursue a wage garnishment to take money directly out of their paycheck, execute a bank levy to pull funds straight from their bank account, or even attach a property lien to their real estate. And here is a fascinating advantage for plaintiffs in Arkansas. The state actually has a remarkably high statutory post-judgment interest rate. It's 10% per year. This means that while you are waiting to get paid, or while you're jumping through hoops trying to collect, the total amount the defendant owes you is continuously growing at a 10% annual rate. That's pretty significant. Finally, what if you lose? Well, the decision isn't always final. The losing party has 30 days to appeal the district court's decision up to the circuit court for a brand new trial. But Arkansas prevents frivolous appeals by requiring the appealing party to actually post a financial bond covering the judgment amount and costs before that appeal can even proceed. We've covered a ton of ground today, from filing limits to courtroom etiquette and collections. But before we wrap up, I must leave you with this really important note. This explainer is for informational purposes only and does not constitute legal advice. For personalized guidance, please consult a licensed attorney in your jurisdiction. We highly encourage you to utilize resources like Arkansas Legal Aid and official district court websites to continue your learning, because ultimately, knowledge is your absolute best tool when navigating the legal system. So now that you are the roadmap, what steps will you take today to claim what you're rightfully owed? Thanks so much for joining me on this step-by-step journey.